State of Nevada versus Donald Nielsen.
Defendant Nielsen, I determined there's probable cause for your arrest and detention. Yeah, but I denied it.
He didn't fill it out.
Yeah, he said something
Like
on it.
declined, I think.
Declined, that's the
So-
okay, I'll see if I.
Okay.
I've determined there's probable cause for your arrest and detention, but you declined the public defender appointment. You want to hire your own counsel, represent yourself, or have the PD?
I'll let him defend me.
You what?
I'll let him defend me.
You'll let him. Well, I don't know if I'm going to. I determined that. Were you working when you got arrested?
No. I haven't been able to make it back to work.
When was the last time you worked?
It's been about 3 or 4 months. I am employed, however, making it to work has
Do
been
you have any
difficult.
savings? Do you have any savings from your employment?
No,
Were you
Not currently.
renting or owning? Were you renting or owning where you live?
I was renting. I was doing odd jobs to be
Right.
able to stay there.
When did you last have a car? Do you have a car?
I do.
What year?
Yeah, it's a 2000.
All right, I'll go ahead and assign the public defender to represent you, Mr. Nielsen, on all cases permanently. You scored an 8 on the NPRA, Ms. Costa, I'll start with you.
Your Honor, the state's not going to object to an OR release, even though the defendant has a very lengthy criminal history. But as far as the state could see, his last conviction was in 2020 of a possession of drug paraphernalia. He's had many contacts with law enforcement since then, but none have resulted in convictions. We know that he is a user of controlled substances based on the recent arrests, but they just were not filed on. So based on that and based on these misdemeanor charges, the state would not object to an OR with DAS supervision, random drug and alcohol testing, and check-ins.
Over on Mr.
Oh, I wanted to ask you, Ms. Costa, do you know anything about the revoked license? Was due to DUI or not?
Well, in 2020, kind of weird, but in 2021, he was arrested for DUI felony. It was the point in time where our lab was very backed up. We didn't get those toxicology results for a long time, and the case ended up being dismissed. It can be refiled. It should be refiled, but I'm assuming that's what that revocation was based on. He has older DUIs in his history, but that was the most recent one.
You don't know that he was currently revoked during the time period for the DUI. It could be an invalid license.
Yes.
Violation. Yeah,
Yes.
well, I'll leave the public defender on for now. Mr. Nielsen, it may be that you don't qualify for a public defender because there's no jail on your case, but I don't know that the state's not going to seek jail time. So I'm gonna go ahead and leave the public defender on there. It sounds like there's probably not gonna be any mandatory if you're convicted. We'll leave the public defender on there to represent you. Ms. Costa, any conditions then, just check-ins or what?
Well, Your Honor, he was caught with drug paraphernalia, and were drugs in the car that they're associating with the co-defendant. But so based on that, we would ask for random testing for drugs.
All right, Mr. Murillo.
No objection to an OR release with those conditions.
All right, then that'll be the order, Mr. Nielsen. You're hereby OR'd. You'll be released today. You must make all court appearances that the jail will give you time and date. You want to go with this arraignment date or not?
Yeah.
All right, it'll be
can
October
we?
15th. October 15th, 2023 at 9:30.
Is that the 19th though?
Well,
Oh,
because this is
yes,
bullshit.
you're right, 19th.
As long as I let it go.
Yes.
October
Thank you.
19th, Mr. Nielsen, though, you're going to be ordered to be on DAS supervision, which means you must be reporting to DAS within 24 hours of when you leave the jail or they're at the jail. You can report to DAS, and then you're going to be ordered to have no drugs, no alcohol. You cannot possess or consume any of those, and you'll be randomly tested for those by DAS. If you fail to show up for testing, or if you test positive, you could be arrested. Do you understand?
Over a misdemeanor paraphernalia charge.
They're gonna give you an OR release.
Sure.
You're not gonna
I
be
show-
better.
Yes, sir. I agree. Sure.
If you'd rather, I'll just leave you in jail. You want to just stay in jail, it's fine with me.
That's fine. That's
Your
fine.
attorney
Thank you,
said you
sir.
agree to these conditions. I
I
thought you
agree.
agreed to them.
I do.
Okay, so that'll be the order. Thank you, sir.
Teenage District Court for County of Washington, now back in session. You may be seated. Sorry. Is it Miss Lessel on the other side?
Yes.
Court does call the case of the People's State of Michigan versus Brandon Toma.
Good afternoon, Your Honor. On behalf of the people.
Deborah Schlossel on behalf of the defendant, Mr. Brandon Toma.
All right. All right. My understanding is this is a waiver.
That is correct, Your Honor.
All right.
Your Honor, it will be a waiver on counts 1, 2, 3, and 4, and 7. The people will not be proceeding on counts 5 and count 6. Despite the way his convictions were entered on his lien, they were entered incorrectly. He is not, in fact, a convicted felon, and I was able to confirm that today.
All right. So 5 and 1, 2, 3, 4, and 7.
That is a true statement of our understanding, Your Honor.
And then at the appropriate time, the people wish to be heard on bond, please.
All right, Mr. Toma. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
And you understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
All right. People also for the record waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1, 2, 3, 4, and 7. 5 and 6 being dismissed. As to the circuit court arraignment, Ms. Lussell.
We waive the reading and ask that you enter not guilty plea on my client's behalf.
Defendant having waived formal reading. Pleading not guilty as to all counts. Court will enter that plea. Pretrial will be set for
November 8th at 1:30 p.m. with Judge Conlon.
November 8th, 2023, 1:30 before Judge Conlon. As to bound.
Thank you, Your Honor. Your Honor, at this time, the people are requesting one of two things, either that the court increase the defendant's bond to 50,000 cash surety, or that the court revoke the defendant's bond. First, when this case was entered into JIS, I don't know how this happened other than that count 7 is on page 2 of the information. It was only entered as counts 1 through 6. So count 7 was formed and open by MSP, but it looks like in JIS when the complaint then went, I'm making assumptions here on how count 7 didn't make it into JIS, which then brings me to the arraignment. I believe the defendant was arraigned on counts 1 through 6, which is, I'm hoping, why at the time of his arraignment, he was issued a 5,000 PR bond, despite that my office charged him with felonious assault and that my office filed a bond recommendation requesting 50,000 cash surety. In terms of me requesting the 50,000 cash surety, Your Honor can see the charges on the complaint. This is a situation where there was a domestic violence, or there was an argument in the house between two people that are in a relationship. I understand that likely included some domestic violence. However, that was not included in the police report for various reasons and has not been charged by my office. Nonetheless, the victim had to flee that house, dinner, get into her car, and drive away from the home through a neighborhood. The defendant jumped in his car behind her and drove erratically behind her. Now, he's also charged with OWI for that exact same driving. He had both alcohol and
Methamphetamine, marijuana.
Thank you, I apologize. He had alcohol, methamphetamine, and marijuana in his system during that driving. He is pursuing the victim. She's scared for her life, and he's driving erratically behind her. Ultimately, she's able to take a turn to get away from him. He ends up flipping his car. That's the basis for asking for an increase in bond to what it should have been set at, or what my office requested at the time of, at the time of filing these charges. In terms of revoking his bond, there has been additional information. This defendant was arraigned on June 14th, 2023. Now, because he was likely not initially arraigned on the felonious assault, there is not a no contact order in this file protecting Chris. As far as I'm aware from Lee. So I'm requesting the no contact order, that he cannot contact her in any way, shape, or form. In addition to that, Detective Swantek from Michigan State Police was able to get police reports from Wolverine Lake, which is the jurisdiction that the defendant now lives in, after his arraignment. So there are many reports from April 2023 until now, but I'm focusing on post-arraignment. After he was arraigned in July 2023, the defendant attempted to buy, I'm going to call them shrooms on the record. He attempted to buy shrooms through Facebook Marketplace, and he ultimately was ripped off, so he called the police to report that. In addition, on September 23rd, which I believe was just this last weekend, police were called out to his home for an argument between him and Miss Skinner. He blew a .19. Now, this is not contained in the police report. I believe there might be contradictory information in the police report from the victim not being forthcoming with the police. I have since been informed by the victim, as well as her sister, that during that weekend, the victim and the defendant were engaged in an argument. The victim had to lock herself in the bathroom, and she held the door closed while the defendant was trying to break in the door using a machete. In addition to that, now this, I do not know whether this occurred before or after arraignment. I know that this occurred a couple of months ago is the language, but I don't know what that means in terms of before or after arraignment. The defendant pointed a gun to the victim's head. While we've been in court today, the defendant has been texting the victim about the situation, about being here to testify. The victim texts, and I've not shared this with Ms. Schlessel because I just got this since we've been present in your courtroom. The victim said, I can't sit there and lie when everyone knows the truth. All I can say is that you did not chase me down with a loaded weapon, but we both know that you did have a gun to my head. The defendant responded, the F word is the first word of the text. I know I effed up and I can't take it back, but that's not even why we are here, and you don't have to testify to that here. But then your family is going to take it out on you. I love you, but ask them if I leave you alone and we go separate ways and you just stay with them, if you can just not come. I love you and always will, but this is effed up. I've already been sentenced to 90 days with credit for 31 today for that night. I'm going to jail for it already. He's referring to, he was sentenced in Oakland County today for disorderly conduct. And he was sentenced to 90 days, but if he turns himself in tonight before 7 o'clock in Oakland, he would get 60 days is what I understand. For those reasons, so the post-
Can I just stop you for a moment? I just want to make sure. The incident involving the machete occurred, we think, when?
September 23rd.
Okay,
The same night he blew the .19 with Wolverine Lake.
all right. And the gun to her head, we don't know when?
I just know a couple months ago, but I don't have a date on that.
Okay. Okay, thank you. Go ahead. I'm sorry, I didn't mean to interrupt.
No, thank you, Your Honor. That is why I'm requesting either that his bond be increased to the initial request made by my office, or frankly, that your office, or excuse me, that your honor revoke his bond. Thank you, Your Honor.
Response.
Your Honor, I would dispute that there was a machete involved in the recent event. And as far as the alleged gun event, it is my understanding, Your Honor, that that was prior to everything that was said. He was sentenced today, in Novi 52-1 District Court, and Judge Reed's told him that if he turns himself in before 7 p.m. this evening, that he would only do 60 days rather than 90. He has credit for 1 day. I am asking, Your Honor, if you do have to increase anything. He was under it. He was not under a no contact order, to my understanding, with the alleged victim in the Novi case. And she did want to have contact with him. And it's also my understanding that her family has pressured her to press these charges.
Can I just ask one thing? In the Novi case, is it Ms. Skinner?
Yes.
Okay, go ahead.
Your Honor,
Well, what was that charge?
Disturbing the peace.
yeah, he pleaded to disturbing the peace.
We got in a drunk.
From-
Disorderly person.
From what? What was the original charge?
This disorderly person, drunken, disorderly.
Your Honor, the original charge in the Novi case, disturbing the peace. And that's what he pleaded to.
Okay, all right, go ahead, Ms. Sussel, I'm sorry.
It's okay. Your Honor, I would ask, he has some issues with alcohol. He's going to be dealing with them when he's in Oakland County Jail and thereafter. I would respectfully request, because Judge Reed sentenced him to do certain things so that he does change his life. Your Honor, I would ask, if you have to do anything today, that at least you let him report to the Oakland County Jail first, so that he doesn't have to do an additional 30 days. That's what he was very worried about, is he's not gonna be able to make it to Oakland County Jail on time. I would ask to change any of the terms that you have them take effect at midnight tonight or in the morning, at 12:01. Your Honor, I would ask for the mercy of the court. And Your Honor, he did show up to court today. He showed up to 2 different court dates, this morning in Novi and here. And he waited here many hours, I would add, because this was scheduled for 9 a.m. And we got here from Novi at about 11, and he's been here since. So he hasn't left. He just went outside to smoke a cigarette. He's not, that's not the issue of showing up. And he doesn't even have a car. He took Uber here and paid a lot of money to get here and was gonna take Uber to the jail.
Oh. Have you been reporting to our community corrections?
Yes, I had missed a few times away from this. Something here said I don't have my own vehicle, so there have been a couple of times where I could not fully get a ride or did not have money to take an Uber. But ever since I've been there, I have been testing positive for my THC, which you said I could because I have a medical marijuana card. But I have not tested positive for alcohol. The other night with the whole Wolverine Lake Police Department was the first time I had blown any alcohol in forever. It was a temporary lapse in my sobriety. I was probably clean for 3 months before that.
And Your Honor, he has been clean from methamphetamine for a year, for over a year. So he has been.
Well, anything you want to say about the text messages?
Your Honor, I'm kind of I know it's not by design, but I feel like a little bit ambushed here. And
You guys want to sit down and think about it?
yeah.
I mean, there's not a whole lot there.
Your Honor,
I mean, I don't think it's an ambush. I mean,
Your Honor.
Your client's the one responding, so I mean,
Can I say something, Your Honor?
if you want.
Me to tell me that she was coming, and I know I shouldn't have said anything to her, but she was freaking out, and I love the woman, and I didn't want to see her pain, so I was just telling her like, it's true, but I wasn't trying to threaten her not to testify or nothing. She texted me, and I know I shouldn't have responded, Your Honor. I'm sorry.
What was the part about not testifying?
He said, I know I got left and I can't take it back, but that's not even why we are here, and you don't have to testify to that here. this is but then your family is going to take it out on you. I love you, but ask them if I leave you alone and we go our separate ways and you just stay with them, if you can just not come.
Your Honor, I mean, I can't make excuses for that, but,
Oh, yeah, okay, good.
but,
Glad you realized that.
but I will say that, apparently, when we first got here, this victim or witness was not here. And we were going to bind this over, and suddenly she was here, and I'm told that somebody came to go get her while I was here in the exam and for a different case. And I'm told that her family threatened her and forced her to come. So that is what I think was the impetus for these text messages. I'm not saying they're excused for that reason, they're not, but I just wanted to give you some context.
Well, the last statement is clearly, I mean, I don't know how else to take it except as an attempt to not have her show up. You don't have to show up.
Can I turn my phone into the record, Your Honor? I have told her that if it saves her and my son and her relationship with her family, then come here, tell the truth, the whole truth, and nothing but the truth. I swear to God, I will turn my phone into the record today. I have not been.
Turn your phone into the record. I don't know what that means.
They were entering their text messages. I showed the whole thing, the whole conversation.
What's the whole conversation?
Your Honor, I think it's what he had just said. I don't think we need to go further, but basically he told her if it helps things, then testify and tell the truth. Which is
Right, that's in that part, kind of, but then the other part, you don't have to testify to that today. He doesn't know what questions are gonna be asked. And then you don't have to come.
Your Honor, I can't make excuses for that. All I would say is he's very anxious about making it in time before 7 p.m. at the Oakland County Jail because he doesn't want to do an additional 30 days on top of what he's already doing. And I think that he's a very anxious person. And I think it set his anxiety. He's got some anxiety and depression issues. And I think that has set those into overtime. And I just don't think he was being himself. Is all I can say, Your Honor. I can tell you that the anxiety has been there since this morning when we were in Novi. Because he was afraid he'd be jailed this morning and he wouldn't be able to come here and he'd miss his court date here. And then when he was here, he's afraid he's going to miss his jail time tonight.
Well, part of my problem is, and I don't know what happened at arraignment. I mean, I guess I could go look at it, but I probably don't want to see it. But one clear prohibition was there's not to be any use of alcohol.
Your Honor, that's true. And that's why he was sentenced to 90 days by Judge Reed. He violated that in his bond conditions there as well.
Well, hold on a second. From the September 23rd date or another date?
From the September 23rd date.
Oh, no.
Was a bond violation in his Novi case because of the 0.19.
And so when did the disturbing the peace or whatever happen? When is that alleged to have happened?
In May or June?
That's what we're here for. I think it was May.
Oh.
Because it's been a while out. We had to keep pushing it back. I don't remember.
Are you talking about the Novi disturbing the peace?
Yes, that's what I'm talking about.
I think that-
Oh, wait, no, sorry, I have the wrong case.
No, I'm
Sorry.
saying-
I think, Your Honor,
I think it was May.
yeah, I think it was May, Your Honor. I was not his attorney beginning of the case. I was only his attorney for the sentencing.
Looks like April 14th, 2023 is the offense date listed.
Of that one. I guess, so. This is, it's disturbing to me. Because at some point, So you're indicating that the machete wasn't part of it. Okay, fine.
That's not my understanding, and I was privy to a summary of it, and
Okay, that's fine. But his text messages acknowledge the gun to the head.
Your Honor, I think the gun was for this case.
No,
No,
the gun, no, the gun in the other one was a different gun, and it was like this case that we're here for. A year and a half ago.
All right, so this case precedes the
Yeah.
Novi case, all right. It doesn't help me.
Yeah.
but I mean, the text messages that I'm here, he acknowledges the gun to the head. Because he's telling her she doesn't have to testify about
Well, but is he saying you don't have to say I put a gun to your head? Is that what it said? That's,
that. No, it's, as I understand it, it's saying, well, you don't have to talk about that today. That's how I understand.
well, Your Honor, I don't think he specifically says what to talk about and what not to talk about, and I would ask that you give him the benefit of the doubt.
I don't know how I give this individual the benefit of the doubt. It sounds to me like it's an individual whose life is absolutely, completely, and totally out of control. He's violated, although the bond conditions weren't full, he's violated the bond conditions regarding the use of alcohol. There is that issue regarding the gun to the head, which makes me also then, well, I understand you're making the representation counsel, which also then makes me seriously question the machete. Then the whole crux of this case is, and the felonious assault in this is him chasing her down with a car that he ultimately rolls. And I don't think, how I feel about it after hearing all of this, I don't think this defendant stops until she's killed. Then he stops. Go ahead, he can say what he wants to say.
I just want to say, as far as the chasing her down, I was never chasing her down. The trailer park that we used to live in, the exit is the same way she was going. And when she turned, I left that area. I turned right on the next street and was speeding out the exit when I flipped my car going over the bridge. I was trying to leave the area too, because I already knew she had called the cops. I was not chasing.
Oh, well, that's good. So the police are gonna get called and you decide you want to leave.
Well, I was being accused of a lot of stuff, so I freaked out. I'm sorry. I have bad anxiety, as my lawyer said.
Hey, you want to say anything else before I'm finished?
Your Honor, I
You can
think.
say whatever you want. I mean,
I think we've addressed it to the best of our ability.
so as I was saying, I don't think with this defendant, this ends until she's dead. And then he has nothing else to chase, nothing else to sort of terrorize or do whatever. I don't think, and like I said, I don't even know what to do about this bond because I don't understand even under those, even without the last charge, I don't know why, I don't understand how this gets set this way. Of rights, what I should do is I should just revoke your bond, which is really what I'm inclined to do at this point in time. However, I don't think, I mean, because this is going to go up before Judge Conlon, that revoking your bond really necessarily does anything at this point because he's going to ultimately set a bond in the case. But what I will do is I'm going to increase the defendant's bond. It will be set in the amount of $75,000 cash as surety for the violations to date. And also the court is doing that because based upon what I've heard, the defendant poses a significant risk to the community as well as to Ms. Skinner.
Your Honor,
Particularly, yes.
can I ask that that take place at 12:01 or at 7:30 PM so that you can get to the Oakland County Jail?
Oh, not a chance. Go ahead. Did you want to say something besides? That's not gonna happen. It's gonna happen right now. If he doesn't get to Oakland County Jail, then that is not my worry. I'm gonna be honest with you. I don't understand why this defendant is out at this moment. Bond has increased 75,000, cash surety. He doesn't, I have to give him another date for pretrial. I have to give him a name date. No, pretrial. Yes, ma'am.
So October 11th.
So pretrial will be October 11th,
Is that at
2023
1:30?
at 1:30 before Judge Conlon. Defendant is remanded.
Okay.
What? Yes, court of standing recess.
Let's go on record in the matter of Eric Orozco, 221035, and appearance counsel.
Morning, Your Honor. Christopher Shemke, appearing on behalf of my client. This time we consent to the matter being heard via Zoom. Mr. Roscoe, can you please state your name for the record?
Eric Orozco.
Okay, I apologize. All right, and today is the date scheduled for probation violation. Your client's on probation for operating while intoxicated and driving while license suspended. And it's alleged that he failed to appear for drug test August 22nd, tested positive for marijuana August 23rd, failed to appear for drug testing August 30th, and failed to appear for drug testing September 14th. And counsel?
Yes, Your Honor. I've gone over my client's rights to have a hearing in which you could contest these violations. That will not be necessary.
All right, Mr. Orozco, please raise your right hand. You solemnly swear from the testimony about to give this matter to be the truth, the whole truth, and nothing but the truth.
I solemnly swear.
All right, thank you. All right, and so you heard the allegations that were placed on the record, correct?
Yes.
As to those allegations, sir, how do you plead?
I guilty.
And you've gone over the probation violation advice of rights form with your attorney, correct?
Yeah.
And you understand all of those rights.
Yes.
You also understand that by entering into a plea, that you'll be waiving your right to a contested hearing.
Yes.
And you've gone over the possible penalty as a result of your plea, correct?
Yeah.
Is that yes?
Yeah. Yes.
And the recommendation specifically is to revoke your probation, close the case without improvement, pay a $50 probation violation fee, and 30 days jail. Do you understand that?
Oh man.
I'm making you aware, sir, as to what the possible penalty is, and that's the recommendation. Do you understand that?
Okay. Yes.
Okay. And knowing all that, do you still want to continue with your plea?
Yes.
Okay. And counsel, if you can please, I'm sorry, before, has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea today?
No.
All right, and counsel, if you can please pardon your client.
Yes, as term condition of your probation, you were to test as ordered. Is that accurate?
Yes.
All right, you in fact missed at least 2 dates, specifically August 22nd and August 30th. Is that accurate?
Yes.
All right, and then furthermore, a test that you took on August 23rd reflected the use of marijuana. Is that accurate?
Yeah.
Satisfied, Your Honor.
All right, the court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation hearing and indicate that technical violations 2, 3, 4, and 5. And counsel adds to the recommendation.
Your Honor, I'd ask that jail time be suspended at this time. I would note that if this was simply a circumstance where my client had done nothing with probation, obviously jail would be something we would be very concerned about. Not that we're not concerned about it now, but rather to reflect on the fact that he has done a lot of his other terms conditions. I asked him about the marijuana use. He indicated he took the CBT supplement, a CBD, because he was having issues sleeping. But Judge, based on some of the outstanding strides he has made with probation, we'd ask that there be a jail review when determining the appropriate admonishment for this case. Thank you, Judge.
All right, thank you. The court will note that Mr. Orozco was sentenced to 24 months probation August of 2022. And that there was a probation violation hearing, well, there's a probation violation scheduled for September 2nd. It was rescheduled to September 14th. And that hearing was held. Your client was found guilty on the violation, 5 days jail, 30 days on the alcohol tether. And then there doesn't appear to have been any violations until just recently. And sir, what's going on? Why did you miss all those drug tests?
I've been, you know, I absolutely do my absolute best to get to my drug test, and I always make it to my drug test. To whenever my color's called, I always make it, and the issue is I don't have any urine because it'll be right after work or something. I've been moving all day, sweating, and they just tell me to come back tomorrow or come back a certain day, and I don't make it. But you know, other than that, you know, I've been doing my absolute best to get this probation and you know, getting a lot of relapse prevention done. You know.
Sir, if you're tested today, what's in your system?
If I were to test nothing, nothing. If I were to test today, everything would come up negative. I'll be completely clean.
Okay. So I still am not really hearing why you didn't show up for your testing for those August 22nd, and then you show up on the 23rd, and then you didn't show up on the 30th, and then you didn't show up on September 14th.
Whoa, that's 3 dates?
Yes.
As like from what I'm aware, I've only missed 1 day. I mean, I check absolutely every day to for my color. Like that's one of like my priorities that I have to get done, you know. But from what I'm aware, I've only missed I think it was the 8th of September.
The 8th? No, sir. On the 1st, you were there, but you couldn't produce a sample. That was September 1st. There's not a missed tester for, what'd you say, the 8th? No?
Yeah.
Is that yes?
From what I'm aware, I've only missed 1 day this month. I mean,
this month for September, yes, September 14th. But you have August 30th and August 22nd that you missed.
Oh, well, I mean, I didn't know. I can, I can start getting tighter about that. Like I said, I do my best. Sometimes I get out of work really late, so I just check the next day. But it's always a priority to me to get those tests done.
Okay, well, sir, here's what I'm unclear on, and you've not yet given me an answer. You seem to have been doing well from September of last year until August of this year. So you were calling every day because I don't have a violation that's been before the court. So you've been going for your testing. So August, you fell off the radar somehow and you stopped your testing. So what happened in August that you stopped getting to your testing as you have been for the previous 11 months?
You know what? I honestly could not tell you because usually I get my sheet sent when I go to get tested, but I haven't been getting it signed lately. She just tells me that it's okay. But I can assure you that it was probably just me not being able to urinate or just if I'm not or my urine was too white. There's been instances where it's too white and they tell me to either come back tomorrow or I can't get a test. But I mean the results, I mean the proof will show you that, these meetings, these urine tests are, prioritized by me and those, considered important by me.
Sir, I don't doubt that that was the case up until August of this year. And sir, if you were there and you couldn't produce a sample, then there would be a note to that effect. But the note reads, did not report for drug and ETG testing. Did not report for drug and ETG testing. Positive for marijuana, for THC. Your caller was called on the 22nd, you didn't show up for testing, but you went the next day and showed up for testing. There also indicates when your specimen was diluted. So those are days you weren't there, sir. And not only that, but then you tested positive for marijuana.
Yes, ma'am. I have nothing to say to that, other than I can do better. You know what I mean?
Well, when you say nothing to say to that, sir, you've already pled guilty, so when did you use the marijuana?
I think it was like 2-3 weeks ago that I took some CBD because I wasn't able to sleep. I was having sleep insomnia. My eyes were bloodshot red. I just was not. I was having a horrible time sleeping. It was like
Hold on, two or 3 weeks ago.
I'd say, yeah, like 3 weeks ago.
Okay, well, that's after this violation. So then you would test positive for marijuana still, I'm sure, right? Sir?
Yes, ma'am. Yes, Your Honor.
Is there something that you're reading over there? You keep looking to the left on your phone.
No, I'm unfamiliar with these dates, and like I said, I've been doing my best for the past year. Alcohol is not even a subject for me anymore, and been getting my tests done, my therapy done. Other than what I have to prove, I don't have anything to say. I don't do marijuana like that. I don't really. I was having trouble sleeping, and I I tried going to sleep, and I still wasn't able to sleep after that. Just got paranoid.
Okay, well, sir. You have technical violations 2, 3, 4, and 5 now. And so the court is going to revoke probation. Close this case without improvement. You're pay a $50 probation violation fee. The court's going to indicate 30 days jail. You are to serve 10 days. We're going to suspend 20. With a jail review on October 30th at 9:30 a.m. And so you're gonna report today. You're going to email it to Ms. Shaw, and she'll give you the information regarding that.
Wait, so I'm not sure. Am I serving time?
Sir, I just indicated 30 days jail. You're going to serve 10. I'm going to suspend 20. The other 20, whether you serve it or not, will depend on your continued testing and testing negative upon your release.
Can we suspend all 30?
No, sir, you now have 5 violations. 5. You previously served 5 on another violation. So I'm indicating 10 days jail with 20 days suspended.
I have a horrible time in there. I get really anxious and I start throwing up and all that. And not only in there, but out here, too. And like I said, I have a horrible time mentally in there. And I have a year's worth of proof that I've been doing good and been getting my drug tests, all that.
Sir,
Yeah,
I understand that, and the court gave you consideration for that. However, you now have 5 violations. And so the order of the court is 30 days jail, 20 years suspended, serving 10. What is your work schedule, sir?
Monday through Saturday.
Okay, and where is it you work?
Tile,
It's just called Tile.
Michigan Tiles.
All right, well, make sure you have a conversation with your boss so you can report tonight.
Can I check in some other day other than tonight?
Okay, sir. So what are you requesting for a date to report?
I was thinking 10 days, that's insane. Can we do this?
Sir, five violations with this while you're on probation is insane.
I know, Your Honor. I've just been doing my best. The second, I guess.
The second, which was the 2nd of October?
Yeah.
Yes, next Monday? No, I'm not giving you a full week, sir. I'll give you until Friday. You have to report September 25th, September 29th.
Okay.
Email over to probation and to Ms. Shaw, and she'll give you that information regarding that.
Sounds good.
If you don't report, sir, it won't be issued for your arrest.
Okay, so who do I have to report to?
Ms. Shaw will give you all that information, sir.
Okay.
All right, thank you.
What's your name, please?
Dwayne Anthony Jr.
All right, Mr. Anthony. Good afternoon. This is People versus Dwayne Anthony Jr., counsel.
Court record on behalf of Mr. Anthony, Your Honor, waive the reading, stand mute. Has been advised of his right.
Thank you, counsel. The court notes formal reading has been waived. Enters a not guilty plea on your client's behalf. I'll hear your argument as to bond.
That's my client's 37 years of age. Judge, I don't see any assaultive history. He does have some priors. He works as at a store. He's a stock gentleman. He's going to go to his dad's house, Judge, to stay, so there won't be any contact with his fiance. So that is what we're asking the court to consider, no contact, as well as a personal bond, Judge. And Mr. Anthony understands the seriousness of these charges, and not to go back over to the location where Ms. Cobra is.
Yes.
All right, thank you. Defendant is charged as alleged to have gone to the complainant's home armed with a gun and began arguing with her through the bedroom window and threatened to shoot her. Then police were called. Police observed him with a gun in hand and him firing a shot into the air. I do sense dangerousness to the complainant. If he's out for that reason, I am setting what is meant to be an unaffordable bond in the amount of $500,000 cash, no surety.
Well, Your Honor, when I read the write-up.
One moment, please. No contact or attempted contact with the complainant, meaning no verbal contact, no written contact, no contact through third parties or social media. Any attempted contact would be a violation of the conditions of the bond. Also, not to purchase or possess any firearms or other dangerous weapons during the course of the bond. There will be an unaffordable bond review hearing June the 6th. That's Tuesday at 9 a.m. in front of Mechanico. Probable cause conference currently set for June 13th at 8:30 a.m. Preliminary examination set for June 20th at 8:45 a.m. Both of those in front of Judge King. Yes, counsel.
As I was going to say, now you read, and I'm going to know if the court believes, understanding that this document is a hearsay document, that Mr. Michael had a gun in his hand, that he raised the gun in front of the police and then shot the gun in front of the police, and he's still standing there. So I don't think that happens just like that. And I don't think the court, hold on, stop, Mr. Anthony. I mean, obviously, Judge, it's written a certain way, but I can read kind of through this thing. It's a lot of things that aren't adding up, and I understand the court has to look at.
Oh, I'm sorry, counsel. Complainant showed the police video footage of the incident where they observed the handgun in defendant's hand and him discharging the weapon in the backyard. So that explains that.
They said they observed something.
That explains more, Judge, because I don't believe the police would have said that they saw him holding a gun. Thank you very much.
All right, well, thank you for the point of clarification. You were right about that. They observed a video of what she said was the incident. Sir, I understand your hand is raised. Counsel, I'm sure is going to advise you to remain silent, but I'll give him the opportunity to do that. You will be in front of another judge on Tuesday who will reevaluate this bond. Counsel, do you want to speak to
that bond again is what, Judge?
$500,000 cash, no surety.
Your Honor, they never said that I had the gun. They said that she had showed her footage and they seen something that looked like a gun in my hand. They never said that I had the gun on me. They never said that. They never said that though.
Right.
They never said that.
Okay.
So so it would sound bad. I'm not a bad person. I'm not a bad person. I don't do things.
Well, you know what, sir? At some point, a judge is going to get to review that video. Your attorney's going to get to review that video. Right now, this is all I have to go on. And so this is my decision at this time, but you will see another judge on Tuesday who may do something different in your case.
Thank you very much, Your Honor.
Thank you.